Alright, so part four of the district attorney's response. So it says 5. Why this response is strategic? It says this does three important things. It keeps your response focused and reasonable. It prevents them from claiming it's too broad. It locks them into producing exactly the kind of records that show timeline manipulation. Ooh, let's get it. Number 6, it says what to expect next. After you send this, Olson and Olson will likely review the records, ask the Attorney General what must be released. You will get a copy of their brief to the AG, a copy of the AG decision. Says that is normal TPIA procedure. 7, important. Do not add anything else. Do not expand the request. Argue your innocence. Uh, mention Vincent directly here. Says add new categories. Keep this laser focused. Bottom line, this email is actually progress. It says they have acknowledged you, assigned counsel, and asked for a narrow clarification, which you can easily provide. It says send the response above, and you stay in full control of the process. So yeah, man, we moving, y'all. We really trying to stay in control. That's why I said, y'all, like doing this, like I'm in a driver's seat. You know what I mean? I'm not waiting on no lawyer. I'm actually putting in the work, and they have to respond to me. Like the district attorney emailed me. You know what I'm saying? From his personal email. You know what I mean? Like I'm talking to this cat. Like not just talking to him, but we replying. So that's all I can ask for, bro. Like I'm making noise. You know what I mean? I'm gonna be heard. Like they can't stop me. You know. But I don't want to. Yeah. So okay, on to the letter. Let's get some more clarity on the letter itself. So it says, good. This document actually tells us exactly where you are in the process. You are going to translate this step by step so you understand. Hold on, I'm going to translate this step by step so you understand what is happening and what, if anything, you need to do right now. So it says, number 1, what this letter is. This is a formal notice that the Galveston County District Attorney's Office has asked the Texas Attorney Generals to decide whether they are allowed to withhold records from you. Why you want to withhold records from me, baby? Come on, baby. Come on, baby. But it says this is called a request for an Attorney General's opinion under the Texas Public Information Act. It said it is a standard procedure, legal procedure. It says number 2, what they are doing says they are saying we have records responsive to Mr. Jonathan's request, but we believe some of them are legally protected, so we are asking the Attorney General for permission to withhold them. All right, y'all. So part 5 of the district attorney's response. So again, it says what they are doing. They are saying we have records responsive to Mr. Jonathan's request, but we believe some of them are legally protected, so we are asking the attorney generals for permission to withhold them. This means two very important things. Important. It says, A, they do have records. This letter confirms GCDA contains the requested information is accepted from public disclosure. So it says, so they are now saying no records. Hold on. Damn. So they are not saying no records exist. They are saying records exist, but we want to keep them secret. Take a moment right there, bro. It's crazy. Like you don't know this stuff, bro. You don't get told this stuff. Like I'm literally learning this stuff on the fly, and it actually feels kind of good, man. Again, I can't say it enough. Like it feels good to be in the driver's seat, like seeing this stuff come right at you. You know what I mean? You get to internalize this and kind of understand how this stuff really works. So then it says, my bad, y'all. So it says, like again, records exist, but we want to keep them secret. Says that is actually progress. Says the 3, the exceptions they are claiming. They list several legal reasons they think they can withhold documents, including privacy, Texas Government Code 552.101, attorney work product. Says attorney-client communication, law enforcement sensitive information, motor vehicle information, 911 call information. None of that stuff. The law enforcement sensitive stuff, the motor vehicle info, the 911. We're not even worried about that. So then it says in plain English, they are trying to argue that emails between prosecutors and DPS, internal notes, strategy memos should be hidden from me or from you. So it's a lot, y'all, but let's get there. So then it says, what happened next? What happens next procedurally? So here is a timeline now. Within 15 business days, the DA must send the Attorney General a copy of the records, a legal brief explaining why they want to withhold them. After that, the Attorney General reviews everything. The AG issues a written decision. That decision will either say release the records, you can withhold certain portions, release some, redact others. None of that, like redacted. Do what you got to do. We don't care about the info. We need emails. We need stuff like that. You know what I mean? We need to see what happened. That's all we want. That's all we want to do. We don't care about the stuff, the sensitive stuff. Keep it. And it says, what you do now, what you need to do now, right now. Nothing yet. That's crazy, right? It says this letter is informational. It says you do not need to respond, argue, file anything, contact Ocean. Right now, you are simply waiting for a copy of the DA's briefing to the AG, then the AG ruling. Says 6. Why this is actually good for you. It says, think about it. If the records were harmless, they would just give them to you. Instead, they are hiring outside counsel, asking the Attorney General for protection, claiming attorney-client privilege. Bro, this world is crazy, right? This law world. This Jesus Christ, man. Jeez. So then it says, it says that usually means there are emails and internal records that shows exactly when and how the DNA narrative changed, which is exactly what you're trying to uncover. It says 7, very important distinction. It says, remember, the process only covers DA office records. It does not cover DPS crime labs, raw data, electropharograms, analyst bench notes. Those come from your separate DPS request, which is still its own track. So it says, your strategy moving forward, you now have 2 parallel tracks. Track number one, DA records. This letter, waiting on AG decision, will reveal internal communications. Number 2, DPS records, raw scientific and DNA data. Analyst Vincent's actual work. Both together will let you compare. It says what prosecutors were told, what the labs actually found, and when each happened. So it says number 9, what to do when you get the next mail. So as soon as you receive the DA's briefing to the AG, the Attorney General's final ruling, whatever, send it. It says this is when we will analyze what they're trying to hide, identify what must be released, plan any necessary appeals and challenges. Bottom line, this letter is not a setback. It is a formal proof. It is formal proof your request is alive, records exist, and the state is trying to control what you see. You are exactly where you're supposed to be in the process. So, bro, we where we need to be. All right, we getting somewhere. That's all that matters. And it hasn't been a long period of time since I started this. I started this November 30th. We in February. What's today? February 8th. You know what I'm saying? So, you have to be patient, and I have to take my time, bro. Like I have to calm down because it's a bunch of it's all up here. It's all mental. It's all mental more than anything. You know what I mean? Calm down, and I just gotta play the game. I'm in the driver's seat, and I'm going slow enough to where I don't crash. You know what I mean? So on to the next part.